This episode of Byte Club is brought to you by Core 3 Group. Before we tell you what Core 3 Group is, let's talk about what they are not. Core 3 Group is not a large marketing and branding firm. They're not caught up in layers of people and expensive marketing solutions. They do not push opinions to their clients that don't align with the marketing planning they develop. Core 3 Group is a right-sized marketing and branding consultancy focused on personal attention and growing your businesses. Working with startups to well-established businesses, they are knowledgeable, they listen, and they are responsive. Core 3 Group develops marketing plans and solutions that fit your goals, your scope, and your budget. Dynamic websites, social campaigns, design, creative writing, and product staging are all things that Core 3 Group can do for your business. If you're ready to grow your business, rebrand with a business facelift, or attract and retain clients, it's time to contact Core 3 Group. Core 3 Group, where everything about your business matters. To learn more, visit www.core3group.com. In today's episode of Byte Club, we are joined by special guest host Rocco Cozza, in which he and I will discuss why terms of services and privacy policies are very important for all app developers to have. Welcome back, Byte Club listeners. And as I said before, we have a very special guest on today's podcast that I think will be extremely helpful to all of our listeners. Today's guest is Rocco Cozza. He is an attorney by trade, but he's also an entrepreneur. He's also an author and has even done some TED Talks and other things throughout his career. And so I really think he's going to be a very beneficial person to all our listeners, not only from the legal aspect of things, but from the entrepreneurial side of things. And without further ado, I'd like to introduce Rocco Cozza.
All right, thanks for having me on, my friend.
Absolutely. Anytime. I appreciate you coming on.
Yeah, absolutely.
Yeah, so as I had mentioned to you, one of the first questions we get from all of our clients, especially the startup companies, when they're developing a new software application is, what's the deal with terms of service, privacy policies? How important are they? What do I need to know about them? And the first thing I say is, one, if you're going to Apple or Android devices, you absolutely need one as part of their terms.
Absolutely.
But two, I tell them, you got to get an attorney, because there's just some legal questions and things like that I that's not my expertise. And so I think it'd be great for you to kind of talk about terms of service, what they are, how important are they, and whatnot.
Yeah. So let's start with, terms of service and privacy policies are extremely important, but you don't have to overcomplicate them, right? The way I would describe terms of service are really a contract between the user of the software or the app and the company that developed the app or the software, right? That's really what it is. It's saying, here's the terms that dictate how you can use and can't use this software. So that's how I always try and tell people to think about it. The privacy policy really just says what you're going to do and not do with the data we collect on the software or app. The reason why they're so important is, one, a lot of states, California in particular, require certain things to be in a privacy policy or on a website or as part of an app or software if you're collecting people's data. They have it's a CCPA, the California Consumer Privacy Act. And then there's, depending on if you're collecting information or the users are going to be children, right? Then you have to deal with COPA, the Child's Online Privacy Act. So there's a whole slew of legal issues or legal regulations you have to deal with. That's why, having a terms of service and privacy policy is extremely important. It's not something you should take lightly, but it's also not something that should cost you tens of thousands of dollars to do. Right. They're pretty straightforward.
Cool. And so you bring up an interesting point, though, because, they're important. They don't have to be too complex. But
I guess my question as an app user, not as a
Mhm.
developer, is that, should I be reading these privacy policy in terms of service? How legally binding are they? You know what I mean?
Yeah, so they are binding. So there's a couple things you need to understand with terms of service. Let's start there. To make a website or app or software terms of service enforceable in court, you definitely have to have a click to accept button.
Okay.
What I tell clients is typically you want to make that a scroll through and clicked agreement. That makes it even more likely to be enforced by a court, because really it's a contract between two parties. So it is enforceable. You should look. The lawyer in me is telling all of your users you should read those. Do all users read those? Absolutely not. It's something that, if you're using a software, you kind of got to think about it from this perspective. If you're a consumer, it's just an app, it's a game or something, and you're not really concerned about much. Is it important to read the terms of service? Sure. But is it critical? I'd probably say no. If I'm a company using software where I'm putting my data in that software, you absolutely need to understand what's happening.
Right.
You
Right.
absolutely need to understand those terms, because if there's something off in the terms, or IP rights are given a certain way, you need to understand that. And that's where people get themselves in trouble. They don't necessarily, it's more in the B2B space where you see issues with terms of services.
Gotcha. Yeah, that makes a lot of sense. And I guess my other question about that too is, so let's say I am a business that's using a software, and I didn't read the terms of service and I just clicked accept, or or to that matter too, if I'm an individual and I just click accept, I didn't
Mm-hmm.
really read the terms of service. Let's say something happens and I want to take, this software company to court. Is the fact that like I don't really understand what I agreed to going to help me out as the individual user, or is it going to favor more of the software company?
Well, so that depends. That's a good question. So typically, you want to make sure you, as the software company, you want to make sure you write the terms of service in a clear, concise, and almost plain language way. Because the more understandable they are to the general reader, the more enforceable they are. Some courts will not enforce a terms of service if it is purely full of just legalese.
Gotcha.
That's why if you see a lot of terms of services now, they almost read like a book.
Right.
Hey, we're going to do this. You can't do this. It's very colloquial in nature, very plain English. That's why, because that makes it more enforceable. Because you can say, well, the average consumer should be able to understand what this is.
Gotcha. Yeah, and that makes a lot of sense too. And I've also noticed to that point, if you look at a lot of the larger corporations' terms of service, they're almost broken down into sections, and you can like
Yep,
easily search or like
that's exactly right.
ask questions, and it comes up. And so I'm assuming that's why they do that.
That's exactly right.
Gotcha. That's super interesting because like that's growing up, I'm 25, and so growing
Sure.
up, I would use all kind of different websites, and I never once read the terms of service. And it was always a question in the back of my
Right.
mind, like did I just agree to like sell my house or my parents' house to like some guy on the internet? You know what I
Right.
mean?
Yeah. I mean, think about it this way. So the terms of service are always, stuff like that's not going to be in there, right? These are really dictating how you can and can't use that software, and then what's going to happen with everything that's happening within the software, like the information, the data, that type of stuff. The big things I always tell people to watch out for in the privacy policies and terms of service. If I'm a company, I'm using a website or an app or software where I'm putting my company's data on this platform, I want to know what's happening with that. And a lot of times these privacy policies or these terms of service will say, hey, we're going to sell your data to third parties, or we have the right to sell your data to third parties, or we have the right to use your data in an aggregated fashion for our own marketing purposes. You need to kind of understand that and determine if that's acceptable to you or not.
Right.
But those are a lot of things you'll see in these terms sometimes that people aren't even looking for.
Gotcha. Yeah, yeah, and that brings up a good point too, because you now have my mind kind of racing here,
Yeah.
and the point about like making sure people understand what these companies are doing with your data.
Yes.
That brings up an interesting topic because let's take Facebook for example.
Sure.
Like the Cambridge Analytics scandal back in 2016 or 2017.
Yeah.
Basically, they got in trouble because data was. The idea was that they had this graph API that if you were friends with like one person on Facebook and that person was friends with at least 3 other people,
Yep.
this graph API could basically reach all information on Facebook.
Mm-hmm.
And they kind of got pinged, and in trouble had a huge PR nightmare of kind of having to explain to the public, like, hey, this is possible. We do collect this data. We can see your friends and your friends' information, blah, blah, blah.
Yep.
Now, I'm assuming I would be shocked if that information wasn't outlined in their terms of service.
It definitely is.
Right. So, I understand the PR backlash and kind of the nightmare of that, but could people still take them to court over that? Because they didn't technically read the terms of service. You know what I mean? I didn't understand that this would happen, but it's in there.
You'd have an uphill battle and all. I mean, take the law aside and from a common sense perspective, right? I mean, if you're going to say, okay, well, I use Facebook all the time and I get ads based upon stuff I look at,
right.
But I had no idea Facebook was collecting my information.
Right.
I mean, it just doesn't add up. And yeah, it's unfortunate that happens. But that's really, I always tell people, unfortunately, there's not a very high expectation of privacy anymore when you're on social media platforms. If you're putting stuff out to the world, you can change your privacy settings, but you're still using a platform that you don't own, you don't manage, you don't host. That data is going to be used by that company.
Right. Absolutely. And you bring up a good point about common sense too. When a lot of these softwares, when they're free, these people aren't doing it for free. I mean, they have an operation to run. They want to make money off of it. They're making money some way with your data.
Well, data is a commodity. I mean, exactly. It's a commodity, and people don't understand that. And I think the world is starting to shift to really see it that way now. But I mean, 10 years ago, people weren't looking at data as a commodity. It was like, oh, that's not worth anything. That's huge dollars. Like the value of a person, if I can get the data to tell me exactly who are the people within a 2-mile radius that I need to market to that are, male or female, age, 42 to 50 with 2 kids and make $100,000 a year. Yep. That's extremely valuable to me because now I can limit ad dollars to just that market. Like that's what people don't understand. Like when you take that data and you can figure out those things, it increases the value.
Absolutely. And and that's a crazy thing though. I always talk to our clients about is like the pinpoint accuracy of these sites,
Yes.
but it comes down to what you're saying, the data collection. They could, you might not realize what they're tracking, your previous browser history,
yep.
The cookies and whatnot. It's actually kind of crazy when you think about it, but I guess from, my understanding in the discussions here is as long as it's outlined in the terms of service, those companies are safe. In a way.
Yeah. I mean, that's really it because it's unfortunately it's in the terms.
Right.
And that's why, and again, I always tell people use common sense. If you're putting stuff out on social media, assume it's not private.
Right.
I mean, it's just common sense.
Absolutely. I agree. But it is an interesting topic because, like you said, data is a huge commodity. And I'm curious if, the world's going to kind of shift in, individuals almost wanting to monetize their own data. And I know this is far-fetched, but
sure.
Maybe I'm just saying if I'm a business and I have this, or I'm an individual and I'm a valuable individual to certain corporations or businesses who are trying to sell me something, I'm wondering if the world's going to shift into individuals wanting to protect their data more and be more, more private, and try to almost monetize their own data or in a way. And I know it's a little bit far fetched, but
yeah, I mean, so I think to your point, I think there are people that have shifted to wanting to be more private. That's absolutely happening. As far as monetizing their own data, right? I mean, what's the value of a single person's data?
Sure.
But that's kind of what you got to look at. The value of data is in the aggregate. Is that scale? Like if I can, if I have a pool of 100,000 people and I can figure out things from that pool, like that's valuable data. If it's 2 people, it's a little bit different.
Right. Yeah. I mean, that's definitely a fair point. But I'm wondering too now that, like, in a way as well, just playing like devil's advocate
Mm-hmm.
here, these corporations have a lot of power because,
Sure.
you almost can't function in today's society without giving up your own personal data in a way. Like,
Yeah,
I think of
absolutely.
my own business as like, I run ads on Facebook. I run ads on, Instagram and LinkedIn. I use Google G Suite for emails and stuff like that. And I use CRMs and I use HubSpot, and like that's all those companies are collecting data, and like I couldn't
Sure.
operate if I didn't allow that to happen. So it's an interesting double-edged sword in my
Yeah, the
opinion,
market has definitely shifted. Absolutely.
for sure. Yeah, and so on that topic too, there's a lot of interesting questions, but one of the things I kind of wanted to chat about, and it's been a personal interest of mine because I've been
Yeah.
kind of following. It's almost been like an internet meme,
Okay.
and it kind of relates back to Amazon. And so Amazon Web Services, in their terms of service, it's actually kind of crazy, and
Yeah.
I'll read it. But in their terms of service, in section 42.10,
Mm-hmm.
it states that I'll just read it out loud so all the listeners can kind of hear it. It says acceptable use, safety critical systems. Your use of the lumberyard materials must comply with the AWS acceptable use policy. The lumberyard materials are not intended for use with life-critical or safety-critical systems, such as in operation of medical equipment, automated transportation system, autonomous vehicles, aircraft or air traffic control, nuclear facilities, manned spacecraft, or military use in connection with live combat. However, this restriction will not apply in the event of the occurrence certified by the United States Centers for Disease Control or successor body of a widespread viral infection transmitted via bites or contacted with bodily fluids that causes human corpses to reanimate and seek to consume living human flesh, blood, brain, or nerve tissue, and is likely to result in the fall of organized civilization. Now, like, this has been all over the internet as like a meme in a way.
Yeah.
But my mind goes to like, one, what does Amazon know that we don't know? Like, are we experiencing a pending zombie apocalypse? or two, like, is this legally binding? Like, could I stage one of these things and like, use their services?
So put it this way. So that was added as a joke into their terms of service. That's really what the point of that was. So that
Gotcha.
there's been so much talk about that. That was literally added in jest as just kind of Amazon being funny. So does that make the contract non-binding? Absolutely not. Because
Gotcha.
because that's a what if clause. Like if this happens, then this. The CDC would have to certify that, which will never happen.
Gotcha.
So that was kind of added just as a joke. And people took it so seriously and they're like, oh, what is Amazon? It's not. It was literally whoever wrote the terms of service did it as a kind of an inside joke.
That's crazy.
Yeah.
So,
and again, like then once someone read it, because I think the intent behind it was this is going to be funny because no one typically reads these. The one person that does is going to blow up. And that's exactly what happened.
That's exactly what happened. Absolutely.
Mm-hmm.
That's crazy.
Yeah.
But on
so it's not they know nothing about a pending zombie apocalypse or anything like that.
That's funny. But on the flip side of that, let's just say that a zombie apocalypse did happen.
Mm-hmm.
That would hold up in court. Like they would have to abide by that and let that service be used for.
Yeah, so long as the CDC, so long as that first part of the CDC certified that or stated that. Because that's the first part of that clause, right? It says if the U.S. Centers for Disease Control does this, then that's
Exactly.
the first trigger. So that trigger has to happen. Then yeah, technically they would have to let that.
That's wild. So
and again, what they're saying with that too, they're not saying they're saying you can't use that for those purposes. If people still do it, that just means they're not going to be liable for anything that goes wrong.
Gotcha.
That's really the point of that clause.
Gotcha. That's super interesting though.
Yeah.
So like, I guess that brings up another more like back down to earth type question is, so if I'm Amazon in this theoretical situation and the zombie apocalypse happens, the CDC certifies that, and I'm like, oh crap, this is going to cost me a ton of money. Let me quickly switch these terms of service. how quickly can they switch that and that become legally binding? Is it just the fact that as soon as that end user accepts that terms again, it's good to go?
Yeah, I mean that's really why you see in terms of service it says last updated this date.
Gotcha.
And then you just want you want your users to have to reaffirm or accept those terms again.
Gotcha.
So yeah, they could change it tomorrow, and the next time they go on Amazon, that's why when you go on websites you haven't been on in a while, you may get a pop up that says, "Hey, we've updated our terms of service."
Gotcha.
That's why you have to do that.
That's cool. And to that note, so let's say I'm using a software, and today they update their terms of service, but I haven't accepted it yet, and they're still letting me kind of use their website or software. I'm only binded to the original terms of service that I agreed to. Correct?
Yeah, if when you purchased it and that's what you accepted, yes, that is correct.
Okay.
Unless you got some notification that we've updated our terms of service, or they sent you some sort of next time you logged into the software, they had some sort of new agreement that popped up. But if you didn't accept anything after the fact, then you could absolutely argue you're not bound by the new terms of service.
Interesting. So that also brings up another question of mine about like electronic signatures. So like, I know that there's DocuSign and I've used DocuSign for my own business, but like what is stopping people from just having or me sending a contract to a client of mine and being like, hey, like if you click this button to accept this contract, like it's legally binding. Is that okay? Is there something specific about the terms of service?
Well, say that again. So I want to make sure I understand the question correctly.
Yeah. So like, I guess what I'm trying to get at is, so like I've used DocuSign, and when you send like a DocuSign contract, someone has to physically sign that like electronically, and that's obviously legally binding. But is there anything stopping me from like, having a contract on a website and sending that website URL, I guess, to like a client of mine or a customer and being like, hey, here's the contract to sign this contract, just click like the accept contract button, but they never actually physically sign something? Is that still legally binding?
It can be. So yes, it can be. I would recommend not. I mean, typically you want to do click agreements when it's terms of service on a website or an app. Gotcha. If it's a contract, meaning I'm providing a service to you for money, you want signatures on that.
Okay.
Like I would not recommend doing it that way.
Okay, that's interesting. So is the idea that the signature revolves around the aspect of the payment, or is it, like what makes the terms of service different in that it's okay to just have like, a button click to accept it?
Because the way you look at terms of service, this is my contract of how I'm going to use this thing.
Okay.
This website, this app, this software. Contract is there's rights and liabilities of each party. I mean, the terms of service is still a contract, but it's different. The mechanisms are different. So gotcha. I would never recommend a client to, hey, I'm going to build this house for you or build this app for you. You're going to pay me $10,000. Here's all the deliverables. Just click on here to accept it.
Gotcha.
Like that's just that can create too many issues in my opinion.
Gotcha. Okay. Yeah, that makes sense. But on the flip side of that, DocuSign, where like someone actually physically, signs.
Yeah, electronic signatures are valid. They're enforceable.
Gotcha.
Absolutely.
Interesting. So, to that nature too, like back to the a traditional terms of service. Let's say that it would go to court, an argument over a terms of service. Generally speaking, are those like, what is the end goal of like, I get like as an app user, is their end goal to get damages, and like what damages could they really achieve from that? You know what I mean? Like I have a hard, like I don't have a good understanding of how someone could achieve damages for something that's caused by an application or software.
Well, that depends, right? I mean, there's so many different variables to it. It may not be monetary damages. It may be an injunction to stop doing something or to give me my data back, or there's not just monetary damages in court.
Gotcha.
There's equitable remedies as well, which meaning, hey, you violated this terms of service. We locked you out of the software. I don't believe I violated it. I need to get back into this software and get my data. And we go to court because I want the equitable relief of being able to access my data again.
Gotcha. Okay.
And again, you don't, at least in my experience, you don't see a ton of court cases over terms of service.
Right. That honestly brings me to my next question is like, I don't even know that I've ever heard of a time of some individual user or business taking a software company to court over a terms of service or privacy policy.
Yeah, I mean they happen. Again, I've been practicing almost 20 years, and I mean there's a handful of cases I'm aware of. None that I've personally dealt with myself, and I've been in the technology space for a long time.
Right. Yeah, I'm curious though to see if like that'll start changing, with because like everything's going online now. Like I mean, I can't tell you the last time I went to a physical store for anything other than maybe groceries.
Yeah, no, absolutely. I mean, I think as technology shifts and the way business is done shifts, I do think there will be maybe more litigation,
Mm-hmm.
but it can't be certain because with technology comes the ability to solve problems quicker.
Right. Absolutely. And I agree that there's definitely a trade-off. I mean, your
Mm-hmm.
technology helps, and you have to kind of give a little bit to get something, in my opinion. And the way I view it is, I know people are very uptight and protective over their own personal data, and believe me,
Sure.
I don't want my personal information kind of shared all over the internet. But like you back to your point earlier on about common sense.
Mm-hmm.
I mean, I think you're super naive if you just think that, hey, I'm going to use this software and like I'm not sharing any information with this company. That doesn't
Yeah,
make
here's
sense.
what I would say. 10 years ago, 15 years ago, you can make that argument. The
Right.
the way today is like that would just be a terrible argument. I mean, there's an expectation now, the way the world is, the way technology is, that my data is going to be used or viewed by someone other than myself.
Right.
And people just need to get okay with that. It's not going to change.
Absolutely. I agree completely. And it's a tough spot, especially I think for like the older generation,
Mm-hmm.
the people who didn't kind of grow up with, technology or the internet,
Sure.
so to say, I talk about like my grandparents and like they're very private people. Like, I come from a very Italian family and they always tell me like, oh no, like don't share this with people. Don't share information. But like, don't tell people how much money you make. Don't tell people blah, 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 and I'm like thinking to myself, well, I kind of share all that information on like Facebook in a way, like people know what I do on Facebook. People know,
Sure.
where I'm traveling to and this and that. And
Yep.
yeah, it's a different world.
I mean, it really is. I mean, it really isn't. People just need to get okay with that.
Yep, absolutely. And one of the other things, that I've been super interested in, one of the other lawsuits that I've been kind of reading about and kind of following is actually focused around Disney, like Disney Studios.
Mm-hmm.
And so I can't remember the name of the company. I'm trying to look it up now as we're talking about it, but there is this company that they use to do some of their visual effects.
Yeah.
And allegedly, my understanding of this is that this company owns that software. Disney uses that software to, do their visual effects.
Mm-hmm.
And in their terms of service somewhere, I guess there's like a clause that kind of states that this company owns the rights to some of the material that's like generated. And so they're trying to sue Disney for, monetary value of like their movies and say like they're
Yeah.
entitled to X amount of percent of, revenue because they own this portion of the movie because their software created these visual effects. That to me, when I was kind of, hearing about this lawsuit, that seems like BS. Like I think that's a sneaky kind of thing on the software company. And I believe that you're going to say that holds up in court because it's in their terms of service. Disney agreed to it, but it's kind of shady.
In that case, and again, I haven't done a deep dive into it, but I don't agree with what has happened or the arguments they were making. I believe, if I remember correctly, they were trying to make the argument that the software was a literary work of art.
Mm-hmm.
Kind of like it was almost a copyright infringement, because
Right.
it was a literary work of art that was, fixed to a tangible medium of expression once it was stored on computer hard drives. I believe that was the argument that was being made. Problem was they were trying to claim all these damages.
Right.
that they should have been. I just, again, this is unfortunately the reason why sometimes lawyers get a bad name. I don't think that is a great case, in my opinion, because you're basically saying that, okay, if I use a software to create something, so if I use a software to create a legal document,
Mm-hmm.
then every time I use a document like that for a client, they would be entitled to a piece of that profit or piece of that money. Like that just, there's just some certain common sense principles that doesn't sit right with me.
Right.
And again, that's something that, I with all transparency, I haven't done a deep dive into that case. And there's just, it's voluminous, the amount of filings and stuff that was done in that case. In the highlights, you never know what's true or what's not. I just think the argument was, look, was it a creative argument they were trying to make? Sure. Do I think it, is a great argument? No.
Yeah, because I agree with you. Like I like how you mentioned the thing about like common sense. Like I think that's like super important.
Yeah.
With kind of everything. I think unfortunately people overlook that aspect in a lot of things in the world. But like, yeah, to your point about, the contract, and like, if you were a contract software company and, because you wrote this contract, you get a piece of every contract that's signed. Like, that's ludicrous to me. Like,
yes.
I like that. That's not like fair. And like for a court to kind of hold that up, like, I grew up believing that the court systems were supposed to be fair. And like, that seems extremely unfair because like,
Well, right. So remember in the case, if I remember correctly, that their original argument was that these characters that were created, I think it was Avengers and Beauty and the Beast.
That's correct.
They were derivative works. And the judge was like, no, that doesn't work. And then they came up with the copyright theory. They said, well, it's copyright infringement because this software is actually our original work of art. And the judge was like, that's a better argument. So it wasn't the fact that they were entitled. The first argument of derivative works got shot down. They made the argument that this is an actual copyright infringement, the software itself. And again, I think it was a BS argument. I don't like cases like this because it looks like it's just for profiteering.
Right. I agree. And when I first kind of heard about this case and was reading the articles about it, that was my initial reaction, was like, okay, this company, they have this cool software. I'll give them that. And they got a big client now. They got the Disney Corporation.
Sure.
And they got some, 2 big name movies that are huge blockbuster hits, and they want a piece of that action. That's exactly what it screamed to me.
Yep.
And I was curious about it because the details of the case aside, the aspect of that, like, a software company could kind of slip something in like that, is almost shady. And it's like, I understand.
Absolutely.
Yeah. Like, and I understand that like it's legally binding. Like that's on the business or the user to have read that and understand that part.
Yep.
But it's like, a part of me is like, that's a little shady. And I don't know that that's fair to like kind of slip something in like that. You know what I mean?
Yeah. I wouldn't recommend doing that. Absolutely not.
Yeah, but it is interesting though too, because kind of shifting a little bit away from the terms of service ideas, the idea that a company or an attorney could make different arguments, and say like, and the judge kind of saying like, oh, no, this argument doesn't work and this argument does work. That's interesting to me too. So like, at what point in time could like a case, can a judge say like, you know what, you can't argue to this point about this issue anymore? Like, could they continue to appeal this over and over again? Like, how does that work?
So let me take this. I'm not a litigator, so that's that caveat, right? So I don't litigate. So typically, if they lose the argument on, say, summary judgment, which is before it even goes to trial, or if they lose at trial, they can appeal. Right. If they lose the argument, meaning I make an argument, someone files a motion to dismiss on summary judgment, means that I don't have a case or I can't prove my case based upon the facts I presented. Then that I don't believe summary judgment is appealable. But again, I'm not the litigator, so I'm definitely the wrong person to ask on the process.
Gotcha.
But you can make multiple theories in a law. So you got to have, as a lawyer, we've got to have a factual basis to make them. We can't just make stuff up. We have to be able to support our arguments.
Right. Yeah, that's super interesting. And last thing I kind of want to talk about on this topic of this lawsuit is that the thing that really caught my eye the most about this lawsuit, in particular, and the reason why I kind of wanted to discuss this a bit, was that let's just say that Disney would have lost this lawsuit. I'm actually not even sure if the lawsuit's still going on or what the final verdict is, but I'm assuming Disney would probably win. But let's just say that in this theoretical situation, Disney loses and a court rules that, you know what, the actual software company is entitled to rights of that work. That would completely change the music and movie industry, on its head, because, we rely in today's world on software to make all kinds of music, movies. You even rely on software to make software. So if something like this were to hold up in court, this would change the industry completely, because now you would force these individual companies such as like Disney and Universal Studios or Sony Pictures to actually create their own software to do their own visual effects, and you're essentially like ruining. You're making, in a way, making these companies more powerful because they're not going to outsource their software.
Yeah.
And to me, that's the craziest part of that whole case is like, I don't know why they would even want to argue that. Because if I was Disney, I'd be like, you know what? I'm done. You go away. I'm not going to use your software anymore. And you're losing out on that business. It seemed backwards to me.
Yeah. And again, I mean, that could fundamentally change the industry, but I think companies will get smart about, this was kind of like an anomaly, in my opinion. It's not the standard way of doing business. I think it's an anomaly, and I think it's not going to fundamentally change the industry. I think that people would just get smarter about how they're doing business.
Right. Yeah, but I mean, it is interesting though, because I feel like, one, the law in general does dictate the way people do business, and that's even from my end of thing. Like we have a lot of legal paperwork before we even engage with a client. And there's laws and regulations you not only have to follow for those types of proceedings, but also for like the terms of service. And you kind of touched on it earlier on about COPA laws and the California. I can't remember what the name of the California laws were that you stated.
The Consumer Protection Act.
Right. And so the other thing I kind of want to talk about is those laws specifically. I mean, those are actual laws,
right,
in the United States. So there could be criminal charges if like a software company were to not follow those laws. How does that work? Like how concerned should clients be about that?
I mean, you need to understand, and that's the main thing, because there can be civil and criminal penalties, and that is, I would encourage everyone of your listeners that is so if you're going to have an app or software that's sold to children, you need to understand the privacy laws that protect children. If you're selling in California, obviously California has the California Consumer Privacy Act. And it just basically says what you can and can't do with data and what disclosures you have to make. And there can be fines and penalties for violating that. The biggest thing, because we can get into a very complex discussion. I don't think that is necessary for your listeners. The biggest thing is just make sure, because if you're a software creator, you shouldn't be trying to understand these laws.
Right.
That's why you have lawyers. Like that's what you have to talk to someone for. These are things that you have to take seriously, but you don't have to do it yourself. And the other thing is, I would encourage people not to go out and just take terms of service and privacy policies off other websites you've seen. A lot of times people will do that. They'll just go on a website that is kind of similar to theirs, or to an app that's kind of similar to theirs, and they'll just copy and paste the terms of service and privacy policy and maybe tweak the formatting a little bit or make some revisions, but they don't even understand what it says. And that's where they get in trouble.
Right.
So that's, that's really when it comes down to the law and these laws in general, or these laws in specific, pay an expert to help you deal with that. Like, I tell people all the time when it comes to terms of service and privacy policy, and even setting up entities for businesses. If you're not willing to invest in that type of stuff in the beginning, you shouldn't be doing business yet.
Absolutely.
Because that's foundational pieces. And if you get those wrong, you're done.
Absolutely.
So don't go spend $10,000 to get a logo done. Spend a couple $1,000s to get your foundational and formational documents done correctly. Like, that's what people need to understand. And if I could stress one thing, before we close out the podcast, like, that's what it would be. Like, that is extremely important. There are some extremely important things an app or a piece of software or website needs to have in place. And don't be penny wise and pound foolish when it comes to those things.
Yeah, I agree. And I can kind of, speak from experience too. And for our listeners, we've talked about Pima in the past, and Rocco actually was involved and helped us out with the whole Pima project.
Yeah.
And one of the hardest things for me as a young entrepreneur was I had this idea in my head that I'm just going to write software, push it out there, people are going to use it, it's going to be great. What I didn't realize is all the legal paperwork behind that. The terms of service, the privacy policies, the COPA laws. Without someone like Rocco to kind of guide me through that and help me understand that, it would have been a completely different story.
I appreciate that. And it's really, things like that. I try and tell people, like, that's why people like myself went to law school. We're the expert. I don't want to say experts, but we're knowledgeable in those areas. That your listeners are developing apps. I could not do that. I don't know how to do that. Like, that's a world that's unknown to me. That's what they are the experts at. And you have lawyers, you have accountants, you have these people that are service providers for a reason. And that's why, I encourage all entrepreneurs, especially startup entrepreneurs, utilize those resources. Yeah, I know people don't want to spend the money, and it shouldn't be an expensive process or an expensive thought in your head. It should be an investment you're making.
Right.
Like, that's how you have to look at it. And once you understand that the stuff you're doing in the beginning is an investment in your business, then the mindset shifts and you're protected long term. That's what you have to do. But I've seen too many people just, pull terms of services from different sites and then and if you're going to do that, I can't tell you people do it. At least have a lawyer look at what you did.
Right.
Have them check the box and be like, yeah, okay, this is good. Or let's make some change, or this doesn't make sense for your company. That's the stuff people need to think about.
Absolutely. I agree wholeheartedly. And, it's also one of the very early lessons I learned as I became an entrepreneur was you can't do everything yourself.
No, not at all.
You're not the smartest person in the room on every subject. And if you don't reach out to people who are knowledgeable about those certain areas of expertise, you're hurting yourself and you're kind of shooting yourself in the foot. So I absolutely agree with you. I think, especially the important things, like you're saying, like you don't want your business or your app or your software to be in a legal battle over something that could have been prevented had you put in a little bit of money and time to, at the start.
Exactly right.
Well, Rocco, before we close off this episode, I like to ask a question to kind of, of all of our guests that I think would be beneficial to our listeners is, as an entrepreneur, whether you're old, young, whatever you may be, what is the best advice that you could give to an entrepreneur? Because I know you've done a lot of entrepreneurial ventures yourself. I know that's a very broad question, but if you could, sit down with someone and mentor them and give them one word of advice on entrepreneurship, what would you tell them?
I'd probably have to give two really. Okay. I don't want to say pieces of advice, but just things to think about. One, it'll be the hardest thing you ever do, but also the most rewarding. So when it gets the hardest is usually right before it gets the easiest. And the second thing I would tell people is, as you learn more and develop more, you'll also start to understand how much you actually don't know.
That's true.
And that's the thing that gets people in trouble the most. And they think they know everything. And, even me, I'm 44 years old. I've been practicing law a long time. Every year I realize there's so much more I don't even know. The more I learn, the more I realize that I don't know. And that's just constant. Just if you're an entrepreneur, you should be in a constant state of learning. And that's how you become successful, truly.
That's awesome. Yeah. That's great advice. I really like the part about, the always learning.
Yeah.
Because you're right. And I've been kind of doing my own business venture for the past 5 to 6 years. And every year there is something new that comes up that I have to learn.
Absolutely.
And, either reach out to another expert or, build upon my team so that I'm not weighing everything myself.
Yep,
So
that's exactly it, man.
it's awesome advice. And thanks again, Rocco. I really appreciate you taking the time to hop on the episode. I really think that our listeners are going to benefit tremendously from your insights and your information.
Well, it was my pleasure, and I appreciate you having me.